Hey everyone, my name is Marc Powers. Thank you, Michael. I'm excited to be moderating this panel. I have Jacob Martin and Dr. Justine Herrera. And in a moment, I'll give a brief introduction as to their backgrounds and why we're doing this panel. But let me frame this if I could. You heard in the last panel, Bruno or mention that people need to understand what's involved when you buy NFTs or you develop or create these NFTs, because there's a lot of lost assets that occur in the digital space. And so what's important to also understand is, why does this matter? Why do you need to understand the legal impact? Well, there's a case called Friel v. Dapper Labs. And for those of you that know this space, you know that Dapper Labs has been collaborating with the NBA Top Shots and helping to create the moments that people have been buying on the NBA website. Well, guess what? Back in May, there was a case, class action brought in New York State Supreme Court, arguing, or at least alleging, that those moments are quote unquote securities under the United States federal securities laws, and they should have been registered. And so it's important to at least have lawyers such as Justine or Jacob, and maybe Josh will be joining us as well, to be able to go to and speak to about these kind of complex issues that occur both domestically. Jacob has done work, is here in the States, and Justine is international. So let me briefly introduce, and then I'm going to turn it over to them to expand upon their background a bit more. So first we have Jacob Martin, who's referred to by many as his Twitter handle, the NFT attorney, and has been working on and with blockchain technology since before he was a lawyer. And at this point in his young career, he is one of the leading attorneys in the United States, working on all things related to NFTs, with a mix of DAOs and general corporate or IP work thrown in. He says that he's not a securities attorney, but he finds himself most of the time also discussing various fungible tokens on a daily theme. So welcome, Jacob.
Thanks, Marc.
Then we have Dr. Justine Scara Herrera. She is a managing partner at MK Fintech Partners, which is a Maltese law firm, which is part of the Michael Cipriano and Co. LLC group. And that law firm is a top-ranked firm in the what's called the Legal 500, and is the third largest in size in Cyprus. Justine's area of expertise include fintech, blockchain, crypto, and investments. And she mainly deals with advising and licensing from issuers of NFTs, tokens, whatever they may be, digital assets, and the service providers around that are involved with them, and which fall under the Maltese Virtual Financial Assets Regulations, so that involves blockchain and crypto, Investment Services Act, which involves capital raising, and the Financial Institutions Act, which involves just general regulation of financial services. Her past work experience gives her the ability to apply her diverse knowledge in a holistic way, and her previous work experience includes working for Exante, an international bank and a leading criminal law firm. She has been chosen to be a member of Malta's think tank, which was a digital economy task force set up by the government of Malta back last year in June. And she's also a true academic at heart, and in her spare time, often publishes research on various topics and speaks at events worldwide. Very briefly, I, as Michael said, I'm excited to be here because I practiced law for 40 years at a law firms, the first 5 of which actually was at the SEC, United States Securities and Exchange Commission. And the last 20 have been at 2 what's called AmLaw 100 law firms. I ran our securities litigation regulatory practice, as well as our investment fund practice for the firm nationally. But now I have fun being a professor, an adjunct professor of law at Florida International University, where I teach blockchain law and fintech law to law students there. And I've done that since the start of this year, after deciding to retire from law firm practice. I'm also a columnist for Cointelegraph, so you can read what I've been writing on different topics since January of this year. And since 2017, I've been involved both representing clients in the blockchain space as well as investing in the space. So with that, thank you all for being here. And I'm going to first turn it over to Jacob, who can maybe tell us, if you don't mind, in a couple of minutes, a bit about your, business that you're involved with, your years in the space, and the work you've been doing.
Yeah, for sure. Yeah, like you said, I've been doing this since before I was an attorney formally. Nice. I so when I was 21, 22, entering law school, I fell on the blockchain rabbit hole. So this has been early 2016, mid 2016, but obviously that was just from an academic standpoint. I was a student. I didn't have any money. So I read a lot, I learned a lot, and then was lucky enough to work as an intern during the ICO boom. So I saw all kinds of paperwork and all kinds of chaos. I loved it. So I raised venture funding while in school to try to build smart contracts. I think smart contracts are going to remove so much friction in the world in general, purchasing everything from an NFT, which is where we're at now, to real estate and cars and boats and other things in the future. I think supply chain logistics and day-to-day goods are all going to be, for the most part, we can do smart contracts instead of paper. So yeah, where I'm at today is I've worked with several Fortune 500s, a bunch of artists, quite a few DAOs, artists and collectors, auction houses, whatever. I've formed a DAO. I basically pulled together Ready Player DAO, which, we just saw a video here from Gala Games, and the group I put together is focused on play to earn blockchain gaming. So so I'm in the trenches on the legal side, on the business side, on the investing side. And happy to get into whatever we get to.
Okay, super. Thank you for that, Jacob. Dr. Herrera, if you don't mind, would you give us a little bit of background of the kinds of things that you're looking at and seeing in this space?
Yeah, sure. So first, I'll just correct you on my surname because I know it's a mouthful. So I'll just repeat it for the audience's sake, which is Sherry Herrera, but sounded like Scary Herrera. Could also be scary, so I'll take it. Secondly, as you first introduced me, my background is in traditional law and finance. I worked for a bank, for a leading investment services firm, and the way and reason I rolled into this space is primarily because I was doing a PhD and master's thesis around 5 years ago, and I chose to write a thesis about jurisdiction in cyberspace. Which led me down a whole trail of research, touching upon the Bitcoin, at that time Silk Road, decentralization. So I had a bit of an interest and background before regulation started to come into play. In about November 2018, Malta decided to regulate this space, and they passed a VFA, Virtual Financial Asset Framework, regulating service providers such as brokers, custodians, market makers, exchanges, and also issuers. And we had quite a holistic framework. And now I'm following quite closely MiCA, which is a new EU directive, which, if passed, could seriously affect some of the arrangements and service providers which we are seeing surfacing in Malta and also in other EU jurisdictions. So my background is mainly investment services and financial services applied to current VFA frameworks. Some clients I'm currently assisting with include token issuers, crypto exchanges, professional investment funds, so funds investing in crypto as an underlying asset, and some other service providers. And of course, been receiving some requests in terms of advisory when it comes to NFTs. I believe that the NFT space has not boomed as much in Malta and Europe as much as it has in the US. But of course, we're still seeing a significant amount of interest as we go along.
Well, thank you for that, Doctor. So let me first turn it over now to you, Jacob, to talk about the topic of NFTs and frame the concept of, what is an NFT as it relates to laws here in the United States in particular for the moment, and how could it potentially be classified, and what do you do and what laws do you consider when you advise clients in this space?
Yeah, so I think NFTs as a whole, it's not like everybody uses the same definition for NFT or for DAO. I think the legal structure and the use case are quite different. Not every time, but most of the time, there's like a different angle, a slightly different angle to what's being proposed. So, the way I look at it is if something is like art or a collectible and there is generally no expectation of it going up in value or anyone going, anything specific happening next, you're just buying a non-fungible thing, a unique anything, that is not a security. It's not an expectation, it's a security. But this is why I say I'm not a securities lawyer, but often I have to tell people when they've firmly entered securities territory. So in my experience, NFTs bring about IP considerations, securities considerations, technology considerations, payment processor considerations, sales tax and jurisdictions, right? Like I could rattle through the 30 things. I often have to say, which Marc, you're a 30, 40-year expert in like one thing. I have to say that I'm like pretty good at like 15 different fields of law. And I'm only really good at like a couple, right? Like smart contracts and how they apply to things, DAOs and some of the early structuring. I'm one of the only people doing those things with quite a lot of experience. But yeah, I think it's quite a general, each conversation is like a fire hose coming at me with 12 different angles, and we want to do royalties with this, and we want to share money like this. And so yeah, when something is firmly out of my range, I start recommending securities counsel, whether that's Fenwick or Cooley or Skadden or Latham or whoever. I just send them straight to the top of the chain and say, if you've got the time and energy and money to deal with a potential securities offering, then just go do it the right way. If not, Marc, you're muted, by the way. You're muted.
Let me ask you, with the context of, you said payment platform, like what are the kinds of issues if you're an artist and you're setting things up and you want to, for example, start offering, some sort of design or otherwise? Two things. One, what kind of organizational structure will you indicate to them, maybe think about setting up? And two, what kind of laws apply to the payment systems, like money transmitter laws and the like, if you'd explain those.
Sure. Yeah. I mean, so, for the average artist or creator that's selling something, like they don't have to really worry about how a platform operates from a payment processor perspective, right? Like OpenSea partnering with Visa, though, is going to cause OpenSea to have to pull certain projects off of their website, right? There was a project this week called Turtle DAO that had or DAO Turtles, whatever it was, had a very specific payment mechanism that OpenSea and Visa deemed to be securities-like, to the point that they pulled it off. They just took it off the platform. That's quite a big step for a centralized entity, for a decentralized concept. But then for an individual artist, there's usually a way in which an S Corp or an LLC just makes a lot of sense for them personally, for expenses, income, protection, limitation on personal liability. I say for anyone who's making more than probably 10 grand a year on art or collectibles, like you're in business territory, you're a business now. You need some kind of protection beyond just what you'd get by being an artist. You don't want somebody to take your house.
No, I guess not. No, so right. So you've identified like securities, IP, payments, and corporate law. Obviously, those are some of the high level ones. Justine, let me turn it over to you, if I may, to speak to us about some of the projects that you've been involved with, the EU and the MiCA law that you referenced a few moments ago in the introduction, if you don't mind, please.
Sure. So MiCA, for those of you who perhaps aren't so familiar with European Union laws, is a proposed directive, so it's not law yet, regulating all crypto asset service providers and issuers. And this regulation also makes reference to other prominent regulations, such as fifth AMLD, which is the AML directive. So basically, this regulation categorizes tokens into three main categories, which are securities tokens, so financial instruments as we know them, e-money tokens, so money which is offered, which is fully redeemable and has a claim over the issuer, and then other tokens, which are not e-money and which are not securities, basically. And for the time being, that they are proposing that the issuance of these tokens are exempt from registering white papers. So, for example, NFTs, the non-fungible tokens, would be exempt from registering white papers. However, they may fall within AML regulations. So as Jacob mentioned, the 10K mark would also apply here. So we have a directive called 5th AMLD, and if you are basically brokering or selling valuable goods which amount to more than 10,000 euros, then you'll need to do some sort of KYC compliance considerations. So we sort of have a similar way of dictating and regulating assets in terms of categorizing them and also applying AML considerations, I see from an overview and from what you've said so far.
No, Justine, we're all lawyers, so we use KYC, we use AML,
yes.
every day, right?
Yes,
but maybe there are a lot of listeners that aren't really, people that are viewing this that don't really understand what those laws are. One, the purposes behind them, which would probably be useful for people to understand, if you don't mind, and then how they apply on an international basis, and then maybe we'll switch to Jacob at some point to talk about it, what implications they may have here.
Sure. So, for example, imagine you have a marketplace where you are encouraging or facilitating the buying and selling of NFTs. And if on this marketplace you have persons listing and selling tokens for more than 10,000 euros, there'll be a KYC trigger. So it could be less, it could be 1,000 euros, but as a minimum 10,000 euros, there'll be a KYC know your client trigger, which is basically, which the purpose is basically to see and verify who the buyer, the purchaser is. So where the funds are coming from, so a verification exercise where they will collect certain documentation like proof of identification and proof of address, and this will have to be applied to marketplaces even if they are working on a decentralized fashion. So they will have to apply some sort of off-chain KYC verification and then store the transaction on chain. So eventually, if marketplaces such as NFT marketplaces, which are brokering and facilitating valuable transactions, will also need to apply these considerations. So I think, unfortunately, it will just be a matter of time.
Yeah. So how do you make sure how do you deal with this, Justine, in terms of making sure it's decentralized and won't be deemed to be a quote unquote security, perhaps, right? Because if it's centralized, looks closer and more like a security. How are people structuring these transactions?
So we don't deem a security by if it's centralized or decentralized. Basically, how we in the EU classify a security is just doing something called a token classification test, which is a financial instrument test. So basically, sort of a bond, equity, commodities, these are financial instruments and would be called securities. Other cryptocurrencies which still have value, like Bitcoin or Ethereum, would not be classified as securities, even though they are traded on secondary markets. So basically, I think in terms of securities, we don't just classify everything as a security, and only if the underlying asset is a financial instrument from that point of view.
Mm-hmm. But what about... No, here in the States, it's similar, like where Ethereum and Bitcoin are generally considered to be commodities, right? At least by
they're not for us, so they're not considered. They're like a whole other. They're called either just other crypto assets. Actually, for now, they're not called anything because this MiCA regulation didn't pass yet. So it's basically what's happening in Europe right now is there's a lot of fragmentation. So I can easily tell you from a Malta perspective what Bitcoin or Ethereum or BNB would be classified as. So in Malta, we have securities, so financial instruments. We have pure utility tokens, which are not traded on secondary markets, which are completely exempt from regulations. We have e-money tokens, and then we have a sort of basket of tokens, which we classify by default. So if they are a utility token, which can be traded on secondary markets, such as BNB or Ether or BTC, these would be classified as VFA tokens, and we have a specific regulation regulating VFA tokens. So we've sort of gone a step further. Now, MiCA, this EU directive, which is not law yet, is regulating them in a similar fashion. which they'll either be exempt or have some other specific law regulating them, or if they are security, obviously be subject to securities law. So Bitcoin wouldn't be considered as a commodity and then as a security. We treat them completely different in that respect.
Right. So the part of the lesson here is you need to be prepared domestic, if you're here in the U.S., as well as an international basis, to understand there are different laws that may come into play.
Yeah.
So to follow Jacob with something you were saying, where on OpenSea that they took down one of the NFTs. Similarly on Coinbase, right? They took, once the SEC sued Ripple, right? They took down Ripple because the SEC alleged that was effectively a security. So you have the same sort of thing on the centralized exchanges, because at least the centralized exchanges are taking the view whatever's on them are not quote unquote securities. Or they've gotten, and they usually go and get opinion letters from law firms, such as my former law firm, and like saying that, so that it gives them comfort. Let me turn, if I may, then with that idea, Jacob, to one of the questions I was asked, and maybe you could answer this. So one person asked that they were asking that how far are we from writing a smart contract and perhaps using an arbitrator if the parties can agree on release of funds to replace an escrow company, and what are the legal implications of that?
Yeah, so this is something I actually personally just did. I've just did this 2 weeks ago. There was a Mega Electric, which is one of the big Bored Ape IP, big Bored Ape NFT. I escrowed it personally as a human, right? So I've spun up a new digital wallet. I put my punk in the wallet as kind of like proof that I own the wallet. Someone sent in their NFT. Someone else sent in 10%. And that was the kicker, was there's not currently a system that allows for like a 10% down payment on anything I've seen. I've been told that it's buildable, but I have yet to have a Solidity dev tell me, hey, I'll build it, or hey, I can. So what I did, right, so we did 10% down, Ape in the wallet. We waited 48 hours. And if they didn't send the rest of the money, I was going to send them back 5%. We had it at 5% non-refundable. Instead, they sent in the full amount. So now we've got $1.3 million in ETH, the Ape NFT, and my punk. So I send the Ape where it goes and the money where it goes. And that was it. That was kind of the middleman service, which is obviously not as smart as a smart contract, but there's not a down payment option on anything I've seen. So I don't actually know how far out we are, because I haven't talked to a dev that told me I can and will build that real quick. Like, I haven't had that happen. I've actually got a call later this week on the topic, or next week on that topic. But it's a great question. I personally believe everything is going on chain at some point. I think real estate will go on chain, and there's no way you're going to have to buy a house in cash every time. So a down payment mechanism is going to have to be key, in the same way that I don't like paying rent by writing a paper check every month. There's no reason I can't just click a button or have like an automatic pull from like my ETH. So it's a personal topic that I like a lot, actually.
So let me have another question, which I'll throw to you. Then I want to have Justine pick up on, because it's probably different in Europe. Motto for Crypto asks, is NFT subject to copyright law? So if you don't mind, first give us a little bit of why is it copyright? And I know from the times when I had to kind of work with my copyright partners, it only generally is good perhaps in the US, and then if you want to do it internationally, you have to do something separate. So and a new copyright. But give us a sense on what's involved with that, and what do you think it is now and where it's going to go?
Yeah, so I think it was Primavera de Filippi, who's an attorney, who has made the theoretical argument that when you're buying an NFT, you're just buying a transaction hash, right? You're not buying an image, you're buying a token, and that's a transaction hash on Ethereum. And so I think we're going to see a copyright litigation at some point where someone says, you took our image. Let's say it's Disney. You took our image. And the creator is going to say, no, I sold a token. It just happens to point to an image on IPFS in the cloud somewhere. But I didn't sell that image. I sold the token. Frankly, I think it's going to be one of the more fun and nuanced topics, is going to be copyright litigation.
So where do you think that's going to come out? And what do you think client says, do I have to copyright what I'm doing here?
Yeah.
You say yes or no?
Well, I think obviously we've got natural copyrights, right? So you don't have to
Correct.
like file everything just to say you have a copyright, right? But
well, it's obvious to you, but I want to make sure the audience understands.
Yeah. So there's a thing, at least in the United States and everywhere else who's signed the Berne Convention, which is this general IP agreement, is that if you create it and you put it out there as though you created it and you were the first to do it, you're given a natural copyright, as in you created it. But to litigate something, to say I created it and you stole it, you need to go register that with the government to get proof that there's paperwork. I was a part of a contentious potential copyright litigation earlier this year. I don't really do litigation, but I was involved in one. I think the United States courts are going to lean on consumer confusion. Frankly, I think we're going to have a group of 70-year-olds sitting on the bench, and you're going to have some cheeky young attorney like me that's arguing transaction hash instead of image. And they're going to go, screw you, kid. I see an image. And that's what this guy bought. He bought that image. And I'm going to say, no, he bought this transaction. And they're going to be like, nope, that doesn't work here.
I think it's going to be more, Jacob, because it's Disney against your small client. That's
exactly. I think it's going to be fun. Honestly, I would love to do it. Like, for me,
very interesting.
I don't have 30 years of copyright experience, but if I were to take something to the Supremes, I think that one would be a fun one. And I like the appellate style of conversing with intellectuals, basically. I would like to help argue this one. I think it will be argued at the highest level, and it will get like a voice argument. It won't just be on briefs.
So let me turn
it's
to
an interesting topic.
If I may. Thank you, Jacob. That's really insightful. Justine, can you tell us a little bit about the copyright laws, or otherwise abroad, if you don't mind, and what you think they should be and they are?
Sure. So firstly, I'm just reading some questions in relation to what we're speaking about, and perhaps maybe we should simplify a bit because they're asking. So when we say copyright, we're saying sort of register a patent or get a relevant license or register the copyright with whatever authorities there are. So it could be a piece of music, it could be a piece of software, it could be whatever it is. So that means you are the owner of the asset, and you have all rights to that asset. So obviously, when we're speaking about NFTs, we're just speaking about digital representation of these physical or of these physical assets, really. So, for example, most of the time, creators of NFTs will not be the creators of the underlying asset. However, not always. There are instances where the creator of the original asset is also the creator of the digital representation, such as LeBron James's basketball cards, where he himself is the creator and the issuer. So, of course, there are legal issues, and there are persons discussing things such as exploitation, saying, should it be allowed for someone to sort of use someone's copyright and then create a digital representation, even though they don't own the underlying asset? So I think that is very much open to interpretation. And it's very interesting that you mentioned litigation, because unfortunately, in those instances, we will be in the hands of the judge, and in terms of how they see it and how they interpret the laws. Would they apply the traditional laws to the digital representations or not? Will it be narrow? Will it be broad? Of course, how good will your lawyer be at arguing these points? So we have the same, basically, we have the same instances where someone can register their patent and copyright their work over here. Until now, to my knowledge, we haven't had any contentious issues regarding NFT stealing persons' copyrights. So it would also be interesting to see what stance the judiciary would take in dealing with those matters. So time will tell.
Yeah, and actually thinking about it just a little bit, that's a really good point, Justine. Let me first, so we don't lose it at the end. Justine, what's your contact information, if you don't mind?
Sure. So either LinkedIn, Dr. Justine Sherry Herrera. I mean, that would be the best place, because I mean, my email is not online.
Fine, that's great. And Jacob, your best contact info?
Yeah. So my Twitter is at the NFT attorney, and my email is GM, like good morning, GM at JTM Tech Law.
So let me go back actually to the point that was raised, that this is maybe just a transaction hash and not someone else's property, Disney's. I mean, that argument in a different way, by analogy, it sounds like was argued when Andy Warhol took the soapboxes or took images of other persons, and he basically lithographed them and put different colors around them and duplicated them in different ways to create art. And so he ended up winning those lawsuits, right? So I would speak for the older generation that they're not the 70-year-olds, I'll say that, but I will say to you that I actually believe a lot in the judiciary, particularly here in the U.S., where you have the legislators and the executive branch regularly fighting with each other. And I'm a big believer in the arbiter being the judiciary. So I have confidence in that they'll kind of ultimately get it right. Maybe from a perspective of a 30-year-old, you don't think that that's going to be the case, but but from my perspective, being told, being given the arguments, they can adapt. There was one question which I'll take the first shot at, but I'm happy to hear someone else on. Jank Wonk, is that okay? Will the U.S. change the definition of the Howie Test? My view is no. I view the Howie Test as being flexible enough to be different situations. So, for example, when I started my legal career, when I was a young little pup at the SEC, among other things, we sued a group of people for sales of geographical dental licenses, which we argued were investment contracts, were therefore they're under the definition of securities under federal securities laws. We won. It went up to the Second Circuit, and it was the law for maybe a dozen to 20 years. SEC v. Aquasonic Products Corp. That case most recently got a new life to it because in a Telegram case, the judge in the Southern District of New York, which is a pretty influential court for securities laws issues, he cited back to that case. So there is a lot of flex. I know a lot of people don't think they need. I'm not saying there should be need for legislation or clarity. Don't misunderstand me. But to answer that specific question, definition of Howie Test, it's the Howie Test. Do I think that maybe should be modifications for sandboxes like Commissioner Hester Peirce has suggested? And an exemption from registration for a period of time, which I'm sure some other people can speak about at some other time, or I could happy to discuss with you, someone else at some later point in time. But that's off topic. What's really on topic are the NFTs and understanding that there are securities laws that are implicated here. Jacob, why don't you kind of tell us a little bit more what you'd like to talk about?
I mean, with that topic, right? So the two things that I think crypto and decentralization are going to challenge the most is going to be accredited investors rules. From a securities perspective, I know plenty of people who aren't being Ponzi'd into anything who would love to put $20,000 into investments with their friends, right? DAOs have this promise of a decentralized group of people all putting money together and then going and doing things. And I've seen it happen quite a few times already. That doesn't mean that what they've done is technically legal or has any paperwork, but the use case is already there and provable that a lot of influence and decentralized group decision making, I guess, with group funds can move mountains. I mean, 500 people all putting 10 grand on the tables, probably the quickest way to raise $5 million, right? Start adding zeros to each of those. 5,000 people, $10,000. 5,000 people, $100,000, right? Like, you shouldn't have to be worth $3 million or make $500K a year or whatever just to make a bet like that. That should be a personal decision. Who knows what the lobbying on that looks like, but that's my take. And then secondly, I think, the Howie Test, I mean, I feel like it'd be ignorant to say that the Howie Test will change, but I think what could potentially be on the table is carve outs for certain asset classes or purchasing of certain things with certain expectations.
Right.
Right. Like, if I buy a stock in a company, that's one thing versus if I buy membership units in a social club, and that social club may or may not be cooler now than it was later, or be cooler farther down the road. And so the social club might be more expensive to get in, right? Like friends with benefits. But that doesn't mean that like we invested in a thing that was a Ponzi with expectation that it would go up in value, right? Like there's just, Yeah, I think DAOs are going to require their own carve out for primarily the section that has to do with, buying something and then doing nothing, expecting it to go up in value. We need to get more clarity around what happens if you buy something and then you actually do something to help increase the value, right, of the thing you invested in or bought. I don't think there's enough there yet.
No, that's an interesting point, and I mean, it's a very complicated topic. You clearly have a good understanding of it when it relates to what's security, what's not. A lot of it has to do with the distribution of the NFT and the like, and the raising of money and things like that. Justine, let me turn to you if I might. You talked a bit about MiCA and anti-money laundering and KYC, or know your customer. When will they, and do you think they can impose that upon decentralized compliance, situations?
Mm-hmm. The thing is, so the thing is, they're not going to mold their laws for the decentralized community. It will be the other way around, unfortunately. So as much as I'm in favor of DeFi and not having a situation of over-regulation, the reality is that if they impose KYC compliance, AML, the DeFi community will have to figure out a way, unless they don't want to remain working in a regulated space, which I don't encourage. But if they choose a jurisdiction where there are laws, they will need to mold and change their structure or underlying infrastructure to cater to cover for these regulations. I know that there are some providers which are assisting a sort of hybrid model where certain centralized exercises such as KYC can be done off-chain, and then the transactions will be done on-chain, as I mentioned before. What I think is key to every jurisdiction and every regulator currently drafting laws and researching in these spaces is to sort of find a balance between, consumer protection and validating markets and whatnot, but also not over-regulating in order not to stifle innovation. And that is the sort of chicken and egg we are facing right now.
And where do you come out? So let's bring this towards try to do two more questions, but where do you think things are going to go, and where is it going to land, focusing specifically on NFTs, if you don't mind, Doctor?
Sure. So in terms of NFTs, till now, the MiCA regulation doesn't specifically state that NFTs should be regulated. It actually exempts them from regulation. So it specifically states that if there is a token which is unique and transfers value and is non-fungible, then they will be exempt from issuing and registering their white paper. And then if you have marketplaces which are facilitating listing and selling and buying of NFTs, of tokens, and are dealing with money transfers, they will need to abide by AML laws. So till now, the MiCA crypto regulations regulate a lot of crypto service providers and issuers, but have left out NFTs. But of course, law is also 20 billion steps behind tech and new sort of evolutions. So it could be that in 3 years' time, they will re-amend the laws to cater for NFT issuers and marketplaces. Till now, they are exempt. However, as I said, they will be subject to intermediaries and brokers of NFT marketplaces will still be subject to AML considerations from other AML directives.
Yeah, so, what's very interesting is there's already been, I think, at least a disintermediation of the brokerage piece, because these are effectively, if everybody thinks about it, like OpenSea and everything else, these are the exchanges. There's no broker in the middle anymore, which to some degree I could see the concerns of the US, because those brokers are there to kind of protect the consumer to some degree. Whether it's the FT, in terms of, recommendations, making sure there's disclosure about information and the like. Jacob, why don't you give us, if you don't mind, take us home then on where, is there continuing life for NFTs? Do they get bigger? And how do they change, if at all, from where they currently are, please?
Yeah, so I think, personally, when someone asks me about NFTs or when anyone's skeptical, I always like to ask, have you ever played any video game a lot, right? And you've built up some kind of treasure trove of items or in-game currency or something. And then you felt bad leaving that game to go to another game because you had done so much work in the first game. Once you realize and your mind is open to the idea that every game you play and everything you do moving forward, all of those things you earn in game are going to have some kind of built-in scarcity and secondary marketplace and the ability for you to carry them around with you from game to game or from game to digital location. Then we're like truly in Ready Player One territory. And I feel like Spielberg's Ready Player One was like somewhat of a Spielberg like pipe dream, like when it came out, and it felt like 30, 40 years from now. But it was really like only 4 years early, right? Like 3 or 4 years early. Like we're headed firmly into headsets and digital asset ownership and you know,
the metaverse.
Yeah, the metaverse in general, right? And so the two reasons I don't think this is going anywhere is because, one, I think we're going to take real world assets and put them on smart contracts. Houses, big pieces of art, cars, whatever. There's no better way to track it. I'm assuming passports and other digital identifiers as well. So the use case for a smart contract will never go away. Mm-hmm. And then if all digital goods, in-game collectibles, digital locations, Twitter profile pictures, whatever, if those are also scarce and ownable, I honestly can't see a world where they slow down at all. And I won't be surprised if we do $10 billion worth of NFT transactions this year and see at least $50 to $100 billion of transactions next year, because the gaming market alone is $1 trillion market. So, you know, I think we're headed towards this being more of a way of life than even a market. Like, I think we're looking at a multi-trillion-dollar market 5 years from now that is NFTs, because I just think that smart contracts take over.
And you think gaming is kind of like the engine or fuel for this to some degree?
Yeah, I think gaming is going to be the reason that 80 million teenagers playing Roblox who already know how to buy skins and buy digital in-game assets, they're going to buy NFTs and not even know it. They're just going to know, I own that.
I just buy the stock of Roblox. Sorry, I'm an old school guy.
Yeah.
What can I tell you?
But a 14-year-old who can't even buy the stock of Roblox can buy a skin in Roblox and can have a digitally scarce good, and they say, that's mine, and I can take it with me wherever I want.
Right. That's the allure. That's so interesting. Yeah. So, Jacob, one more time, your contact information on Twitter is?
Yeah, at the NFT attorney. It's cheeky. It's obviously not a real designation, but it's fun.
Right. And Justine, if you don't mind, again.
Very boring, unlike you, Jacob, but Dr. Justine Herrera, just on LinkedIn.
Right. And I'm Marc Powers, MD Powers 2020 at gmail.com. And you can also read my monthly columns on Cointelegraph, where I get to pontificate and have fun in this space and talk about different things that are going on in it. If there are no more, I think we're just about out of time. You guys are amazing. If anyone needs any kind of counsel or thoughts or want to bounce things off of the best young minds or minds alone in the industry in this space, please contact Jacob or Justine. And I thank you all for listening. I thank you for your questions, and I hope you all got something out of this panel.
And thank you for moderating, Marc.
Yeah,
my pleasure.